We would like to request everyone to kindly settle down, and for those who are still outside the venue, kindly find your designated areas inside, for we'll begin in a short while. For the first plenary session, may we request our panelists to kindly proceed on stage. Starting off with the chair, the Director of La Trobe Asia, Professor Rebecca Strating. Next, we have the Research Fellow, the Max Planck Foundation for International Peace and the Rule of Law, Ms. Pham Ngoc Min Trong. We also have the Chair, Philippine Advisory Board, WPS Manila, retired Chief Justice Antonio Carpio. And the Senior Fellow, Research Institute on Contemporary Southeast Asia, Bangkok, Mr. Francois Xavier Bonnet.
Hello? I think we are working. Well, hello and welcome to this first plenary session of the 2025 Manila Dialogue History versus International Law, Understanding Historic Rights and Modern Maritime Zones in the South China Sea. My name is Beck Strading, and it is my great pleasure to be moderating this session today, where we'll be examining different perspectives on the role of history in determining maritime zones and whether there are any pathways towards reconciling historic narratives with binding international law legal norms that centre upon UNCLOS. So the structure of today's first plenary session is we will hear from two presenters and we are also joined by three discussants, and I'm aware that we are slightly running behind, so I'm going to try to ensure that our panellists all keep to time so that we can have plenty of time for Q&A. So please let me introduce our first two presenters. Dr. Wu Shisun, Chairman of the Huayang Centre for Maritime Cooperation and Ocean Governance, and Dr. Bill Hayton, Associate Fellow of Chatham House Asia Pacific Program. We are also joined by three discussants: François-Xavier Bonnet, Senior Fellow at the Research Institute on Contemporary Southeast Asia, Justice Antonio Carpio, Chair of the Philippine Advisory Board, WPS, and last, certainly not least, Trung Pham, a Research Fellow at the Max Planck Foundation for International Peace and Rule of Law. So I will start with you, Dr. Wu. You have 10 minutes to present your case, so please take it away. Or would you like to go first, Bill? Okay, no problem.
Thank you very much indeed, Beck, and thank you to the organisers for having me. Could we get the presentation up, please? Great, okay, oh it is, okay, but I can't see it down there. Okay, all right, well welcome. So Bill Hayton, as some of you may know, I've worked on the history of some of the disputes, and since I'm here with François-Xavier, I want to pay tribute to some of the work that he's done that I've relied on, and Chi Ting is also here, and some of his insights are here. But I wanted to take you back to a time before we had remote sensing and people knew what there was going on in the South China Sea, but to a time before we were familiar with the disputes, the rocks, the maps, and the geography. When, you know, if you were living in Hainan, for example, and this is a picture of a place on the southern tip of Hainan, which is colloquially known as the end of the earth, because what lay beyond it was unknown. And I want to take you back to that time, and to a time when Chinese authorities could produce a map like this. This was produced in 1870. And it's a map, obviously, that shows no islands in the disputed parts of the sea. It does show some islands off the coasts. But at this point, no official interest in the South China Sea. And why am I going to talk about these old maps and places? It's because I think that a lot of what's happening now in the South China Sea is based upon certain understandings of the past, certain narratives. And I think if we could actually, you know, kind of disentangle, deconstruct some of those narratives, it might actually create a space for some kind of conflict resolution. I'm just going to quickly, therefore, take you through some incidents, I think, which demonstrate how China's claim emerged and evolved over the course of the first half of the 20th century. And the first instance is to talk about a couple of shipwrecks that happened in the 1890s in the Paracels. And these shipwrecks involved an awful lot of copper ingots, and these are some of the files from the National Archives in the UK. They were Japanese-owned copper, but it was insured by British insurance companies. And this copper got looted from the shipwrecks by local fishermen, and there was then an exchange of letters. Basically, the insurers wanted the local officials to get the copper and to pay up. But the local officials in southern China didn't want to take responsibility, and in fact, they avoided any official claim to the paracels. And this is a transcription of an official letter from the viceroy of the Liangguang, the two provinces of southern China, Guangdong, Guangxi. And basically he's saying, you know, this has nothing to do with us, these paracel islands. How can we protect what is in the high seas? And you can see the Chinese words that he used there. So 1898, we have the official of southern China basically saying, you know, these paracel islands, they're nothing to do with us. And the dispute went on and on for quite a long time. And basically the British officials weren't actually that interested because they had more important things to do, but they were trying to press the case of the insurance companies. And he goes backwards and forwards. A further letter the year later, and this is from the Zongli Yamen, which was in effect the foreign ministry of the Qing dynasty. And it's basically repeating some of this information from a year ago. But this is the central state of the Qing dynasty. And here, I have an English transcription, or sorry, English translation of the missive that they get from the Qing, talking about these unfortunate shipwrecks on the high seas. Once again, you know, denying any responsibility for the paracels. And then, well, there's an interesting little aside to this, and apart from these comments about, you know, on a wide, expansive ocean, no particular coast guard could be said to be responsible. They're trying to avoid paying out for the insurance claim here, but in the process, they are obviously denying responsibility for the paracels. But they do start talking about a set of islands called the Qizhuyang. And this is the start, or maybe the continuation, of a great deal of confusion in official Chinese thinking, mixing up these two sets of islands, the Qizhuyang, which in English are known as the Taiya Islands, which exist on the northeast coast of Hainan, with the paracels, which are much further south and east, and other islands in the sea. And this is a recurring theme in some of the Chinese correspondence about the islands. And this is, to show you, go back to the old map, this is where the Qizhuyang are based. You can see Qizhuyang up there, and little drawings of the islands. So there's a confusion here in Chinese official thinking about which islands are being talked about when the foreigners are talking about the paracels. Another little incident from a little while later, 1928. So an expedition after the return, or after the KMT take power in Nanjing, an expedition is launched by Sun Yat-sen University in Guangdong to go and explore the islands. But when they come back, they write a report. And it's very interesting, the very first line of this report, this is a university report, but it has an official backing from the KMT. It says, the Xisha Islands, the paracels, are the southernmost part of our country. It's a proud declaration. But of course, what it's telling us at this point is that China has no claim further south than the Xisha Islands, than the paracels. I'm going to run you through, because we're just doing we've only got sort of a few minutes to talk about this. So just picking out some incidents. This is a correspondence when France annexed the Spratly Islands further south in 1933 and announced it on Bastille Day 1933. There was then a flurry of confusion, and François Xavier has looked into this as well in great detail. And there was the ROC Navy asked the Ministry of Foreign Affairs, what can you tell us about these islands? And the Navy responded, there aren't any islands there. So this is a clear confusion, and as François has shown, it was only when the Chinese delegate in Manila actually went and spoke to the Americans that they got a decent map and worked out that there were some islands there. And as a sort of coda to this, if you look in the official Gazette of the Republic of China Ministry of Foreign Affairs, who produced a report on this incident in 1938, you can see lots of discussion about Dongsha, i.e. Pratas, and Xisha, the paracels, but nothing about the Spratlys at all. And in fact, there's a great line there that they've always been part of our country's territory, but they've been completely ignored by us, which under modern international law is basically saying we didn't occupy and administer them. And in the same document, you'll see a reference to Triton Island, the southernmost island in the paracels, being referred to as the southernmost island because it is the southernmost point of the South China Sea. Okay, so there's no knowledge of places further south, no knowledge of the Spratlys in official government. And you can see this sort of same lack of interest and concern. I mean, you know, we hear a lot about how the Cairo Declaration promised the islands to China, but actually, if you look at the text of the Cairo Declaration, there's actually no mention of the Paracels or the Spratlys whatsoever. They mention the Pescadores, obviously an important little archipelago, but that's between Taiwan and Chinese mainland. And if you look at the ROC's official handbook published in 1943, page 1 declares what the territory of China is, and it says it stretches all the way from basically Mongolia to the Paracels. But then something changed at the end of the Second World War, and Chiu Ting-tai and other people have looked at some of the documents to do here. There was an expedition which landed in the Spratlys on the 12th of December 1946. But even after that expedition, there was still an ongoing argument within the ROC officials about which islands should still be claimed. And the guy who actually led the expedition to the Spratlys, Lieutenant Colonel Lin Zun, he argued against claiming the Spratlys as late as February 1947. It was only in a meeting in April 1947 that the ROC decided that it was going to claim the Spratly Islands as far south as James Shoal. And anybody who knows my work knows that the James Shoal is an underwater feature, doesn't actually exist, and was only claimed because of a translation mistake. And so when they produced, the ROC produced the second edition of the China Handbook 4 years later, you'll see that the territory has leapt southwards by about 1,000 kilometers. But you'll even notice that there's a little acknowledgement that the claim is contested with the Philippines and Indochina. So that was a quick run through. I would put a plug for some of the more detailed writing that I've made on this issue, and happy to take questions here and afterwards for those of you who would like to know more. Okay, thank you.
Thank you very much, Dr. Hayton. We now will have Dr. Wu to make his presentation. Thank you, Dr. Wu.
Thank you, Becca. Dear colleagues, ladies and gentlemen, good morning. Let me begin my presentation by thanking the organizers for inviting me to participate in this event. Since today's topic is about the history both of the international law, so I'm going to talk about the history of the South China Sea. My presenter will address your argument. To be honest, frankly speaking, I didn't agree with the majority of your arguments, beyond my friend. More than 2,000 years ago, our Chinese ancestors began navigating the South China Sea and learning about it through maritime activities, discovering and naming the South China Sea islands. At least since Tang and Song dynasties, China began to administer the islands and the nearby waters of the South China Sea. They are all recorded in the rich and reliable records of China throughout the history. In the colonial expansion of the West in the 17th century, France, Bill just mentioned France, and then Japan and other countries illegally occupied some of the China's islands and reefs in the South China Sea, sowing the seeds of the South China Sea disputes today, to be honest. However, successive Chinese governments have consistently and resolutely safeguarded China's sovereignty over islands and reefs in the South China Sea. This picture shows in 1946, Chinese warships going to the Nansha to recover the islands. The Zhongyi Titu Island, now occupied by the Philippines. The stone monument was erected by then ROC government. So, since the defeat and the surrender of Japan after the Second World War, the Chinese government dispatched the sailors and officials to recover the islands in the South China Sea in accordance with Cairo Declaration and the Potsdam Proclamation. So, after the founding of the People's Republic of China in 1949. The Chinese government established administrative institutions in the islands in the South China Sea, dispatched warships for routine patrols, and promulgated laws and regulations to the islands, thus establishing long-term and effective jurisdiction. So China's sovereignty over the South China Sea Islands has also been recognized by international community. For example, I show you some pictures. My picture is officially published, but your map was man-made. From Korea Encyclopedia, published in 1940, to illustrated atlas of the world by Rand McLean Company in 1987. For decades, the words Paracel Islands and Spratly Islands were mentioned in Chinese pinyin, Xisha Chundao, Nansha Chundao, and indicated with China in its brackets. You can see that Xisha Chundao, Nansha Chundao in Chinese Hanyu pinyin. So this reliable history of the South China Sea, supported by historical documents and facts, confirms that China's claims in the South China Sea are in line with the international order and shall be supported by international law. Therefore, history and the international law are not contradictory, in my opinion. On the contrary, only international legal practice based on history can gain its legitimacy. The Western perception that history violates international law, however, is largely due to the illegal occupation of Chinese islands and reefs in the South China Sea by some littoral countries. These provocative unilateral actions instigated by external powers and their deliberate attempts to accuse China of not abiding by international law. So currently, intentions in the South China Sea arises mainly from, frankly speaking, from the Philippines' repeated violations of its commitments and provocations and inability to confront the true South China Sea history. Here, I would like to briefly focus on three key issues between China and the Philippines. Number one is the Ren'ai issue. The second one is the Huangyandao issue. The last one is about the South China Sea arbitration ruling. History on the Ren'ai. As we know, in May 1999, the Philippines deliberately grounded the warship on Ren'ai and stationed troops there. Since then, attempting to change the status quo of the reef. This de facto occupation is essentially and blatantly violation of China's territorial sovereignty over the Nansha Island and also causes serious damage to the marine ecological environment. You can see in the map. The Philippines has repeatedly pledged that it has no intention to change the status quo or constructing facilities on Ren'ai and will not become the first country to violate the COC. It has even promised to tow away the grounded warship. China and the Philippines also reached a resupply agreement just a couple of years ago on regarding Ren'ai, which prohibited the reinforcement of facilities there. For 26 years, instead of towing away the warship, the Philippines has repeatedly attempted to transport the building materials and for the larger scale repairs and the reinforcement. So its unilateral provocations ultimately led to the last year's incident on 17 June. Second issue about the Huangyandao. For time limitation, I will speed up my presentation. The Philippines only began to assert its territorial claims to Huangyandao in later 1990s. However, prior to this, China maintained continuously effective and peaceful jurisdiction over Huangyantou. This is a fact that history tells us. Huangyantou is not within the treaty limits of the Philippines defined by the 1898 Treaty of Paris between United States and Spain and the 1900 Treaty of Washington between United States and Spain and the 1930 Treaty between United States and Great Britain. So both the so-called Kalayang Islands and the Scorpion Shore of Huangyantou are located, be careful, located outside the treaty limits, west of 118 degrees east longitude. The Philippines, from their perspective, claims Huangyantou on the ground of geographical proximity and on the excuse of Huangyantou is located within the EEZ of the Philippines. According to its one-sided interpretation of UNCLOS, however, the principle of geographical proximity doesn't provide a legal basis. And its EEZ-based claim violates the principle of international law, that is, the land dominates the sea. So that's about the last one is about the arbitration tribunal's award since the time. I don't want to look at the subject matter. There are lots of fallacies and weaknesses in terms of legal application, fact-finding, and evidence admissibility. I just want to stress one point: the tribunal's lack of jurisdiction to this case. My arguments are, number one, the jurisdiction of the tribunal is illegal, improperly touching upon the dispute of the land territorial sovereignty, because the problem or substantive issue between China and the Philippines is not about the interpretation on, or application of UNCLOS. It is about a sovereignty dispute. Secondly, the tribunal disregarded China's statement under the Article 298 of UNCLOS. Finally, the composition of the tribunal lacked representativeness, and the arbitrators are nominated by Sujiani, the then president of UNCLOS, a jurist coming from Japan, which were having a territorial dispute over Diaoyudo with China. So my questions to you, my colleagues here, the so-called arbitration award was issued by this kind of tribunal. Do you think the ruling is impartial, neutral, and objective? It's my question for you. The last part of my presentation, the outlook of China-Philippine relations. President Marcos Jr. expressed his hope at the recent ASEAN summit to find a way to defining China-Philippine relations. I believe that the Philippines needs to frame the history in a correct way and address the South China Sea disputes in a rational manner if it wishes to steer its relations with China towards cooperation in the future. So history and modern international law are not incompatible. It is a view which makes UNCLOS panacea that conflicts with history. So China's activities in the South China Sea islands and reefs predate the emergence of the law of the sea, denying China's historical rights in the South China Sea based on inconsistencies with UNCLOS is essentially, from my opinion, denying the historical fact of China's sovereignty and jurisdiction over the South China Sea islands and reefs and the relevant waters. So I believe the key to peaceful resolving the South China Sea issue lies in correctly understanding regional history post-World War II world order, rationally viewing China's legitimate claims and rights, excluding countries outside the region for intervention of this issue, and jointly shaping the South China Sea narrative that conforms to the historical facts, and then finally building the South China Sea into a sea of peace, friendship, and cooperation. Thank you.
Thank you, Dr. Wu. I'm now going to invite our first panellist, Francois Xavier Bonnet, to respond to the two presentations.
First, thank you very much for inviting me. I want to do a short presentation on the fishing activities of the Filipinos before the Second World War. In September 2025, the Chinese government declared a nature reserve of 3,000 hectares over the Scarborough Shoal. This unilateral move from China excludes de facto all fishing activities of Filipino fishermen around the shoal, whether in the core area or in the experimental area. This move goes against the ruling by the Permanent Court of Arbitration, affirming that Scarborough Shoal is a traditional fishing ground shared by the Philippines, China, and Vietnam. Interesting is that the Spratly Islands have not been declared a traditional fishing ground by the PCA. The general narrative is that the Chinese fishermen have been in the Spratly Islands since time immemorial. So in this presentation, I will show that Filipino fishermen were active in the Spratly Islands for a long time, and it was recognized in different documents. My objective is to rebalance the narrative of the fishermen. The Spratly were shared maritime space. It was so vast that the fishermen of the different countries had limited contact between each other. In July 1933, France claims officially the Spratly Islands. This claim was opposed strongly by Japan. Some Filipino officials pushed for a Philippine claim, like Senator Elpidio Quirino. And Chinese officials were confused, as Bill was saying before, about what were the Spratly Islands. They thought that France claimed the Paracel Islands between Hainan and Vietnam. All the Chinese press, analysis, and publication made the same mistake during this period. Only August 1933, the Chinese officials ascertained that the Spratly Islands as Paracels were two different maritime spaces. China did not make a claim because they said no evidence that the Spratly Islands belonged to China. According to a secret report of Department of Military Council of September 1933, they said, we have only one evidence, those of the fishermen from Hainan. But we have never done anything on these islands. We must therefore calm things down with French, but allow our fishermen to continue their activities on these islands in order to protect our fishing rights. Fishermen from Hainan will become the cornerstone of the Chinese claim of over the Spratly Islands through time. The fishermen from Hainan are represented as the only ones fishing in the Spratly since time immemorial, using the Zheng Lubu, manuals of sea routes in Southeast Asia. In British sailing directions, like China Sea Directory, at the end of the 19th century, it is mentioned the presence of fishermen from Hainan on some islands of the Spratly. But in fact, Chinese documents themselves, not for foreign consumption, show that the fishermen from the region were as active as the Chinese in the Spratly Islands. For example, in 1977, a team of researchers interviewed all fishermen in Hainan Island who were fishing in the Spratly in the past. One of those interviewed was Mr. Fu Guohe. He was fishing in the Spratly between 1929 and 1937. Very few fishermen were living on these islands, as he was saying. And he said Malay fishermen were also very active in the area, but the Hainan fishermen did not mix with them. In the confidential sailing directions, the dangerous ground in the South China Sea, published in 1951 by the Hydrographic Office of the US Navy and declassified in 2013, it was based on pre-war secret hydrographic surveys from Japan, UK, and the US. It describes in page 38 that between Flat Island and Nanshan Island, there is a bank. And around this bank, it is known that fishermen from Manila frequent this bank. So it was showing that before the Second World War, the Philippines were already in the Spratly also. This is a map from this 1951 confidential secret survey based on the different secret survey before the war. When France claimed the Spratly in 1933, the Philippine press published many articles of these islands called by the Filipinos Las Corrales. In the Philippine Tribune of August 3, 1933, a Japanese fisherman resident of Manila was interviewed. His name was Woshie Tamashiro. He was in the Spratly during the 1930s to look for seashells. On the largest island, Ituaba, there were coconuts, papaya, and other fruit-bearing trees. On another island, there was an abandoned cottage in ruins, Japanese fishing vessel, and water tanks. It is to be noted that Tamashiro was a partner of Filipino fishing magnate Bartolomé San Diego. And Bartolomé San Diego became the principal sponsor of the famous Thomas Cloma for the expedition to Freedom Lands or Spratly Island from 1947 to 1957. Yes, 57. Then there was also Samuel Stagg, an American who arrived in Philippines in 1921. He was a pastor and founder of the Cosmopolitan Church, developed the Boy Scouts of the Philippines, and was a journalist of the Philippine Free Press under the nom de guerre jungle philosopher. In 1937, he became a Navy intelligence officer and became very keen about the activities of the Japanese fishermen, turned spies around Palawan and the Spratly Islands. During the war, he escaped Manila to join the guerrilla in Palawan. Later, in 1955, he would explain to the press that he had been living in an undetermined time in the Spratly during the war. He didn't give more details, unfortunately. In fact, some guerrilla fleeing Luzon to join Palawan, Mindanao, and other places could pass by the dangerous ground to avoid being caught by the Japanese patrols along the main sea lanes. Fishermen from the Philippines knew how to maneuver well the fishing boats in the dangerous ground. And as the Filipino historian told me, Professor Serafin Criason, the dangerous ground was a real freedom land for Filipinos and American guerrilla fleeing Luzon. The main stopover was Nanshan Island, Lawak for the Filipinos, before going south to Palawan. My hypothesis is that Samuel Stagg was living on Nanshan Island for an undetermined time. This islet was far from the Japanese occupied Ituaba. It is to be noted that Samuel Stagg was a close friend of the famous Frederick Morton Meds, who claimed for himself the kingdom of humanity of Spratly in 1955. Stagg did not condone the activities of his friend, but pushed for the Filipino government to claim the Spratly. He was the advisor of President Magsaysay. He died in Palawan in 1956. In conclusion, Chinese fishermen were present before World War II, but they were not alone, and in fact they ignore each other as the maritime space is huge. Some Filipino fishermen had a real knowledge on how to maneuver in the dangerous ground, and this practical knowledge was extremely useful during wartime to carry guerrilla from one island to another undercover. The claims actors after World War II go deep into the pre-war situation. Thomas Cloma or Frederick Morton Metz, for example, do not appear out of nowhere. They are directly linked to pre-war actors who knew about the dispute between France and Japan over the Spratly Islands and who had practical knowledge of the Spratly. It is a pity that the court in 2016 did not declare only the Scarborough Shoal as a traditional fishing ground for Chinese, Filipinos, and Vietnamese fishermen. The Spratly fit well the definition of a traditional international fishing ground too. Thank you very much.
Justice Carpio, I now invite you to make your presentation. Thank you.
Thank you. Good morning, everyone. there are two disputes in the South China Sea. You have the maritime dispute and the territorial dispute. The maritime dispute is governed primarily by UNCLOS, the UN Convention on the Law of the Sea, and the territorial dispute is governed by general principles of international law. On the maritime dispute, all the disputant states have signed UNCLOS, they're parties to UNCLOS, so they're bound by UNCLOS. And under UNCLOS, historic rights or claims beyond the territorial sea have been extinguished. States agreed that they will no longer claim beyond the territorial sea any historic right. How is this? Under UNCLOS, it states that expressly in the exclusive economic zone, the right to exploit the natural resources, living and non-living, belongs exclusively to the adjacent coastal state. So the Philippines has the exclusive right to exploit its exclusive economic zone. That's why it's called exclusive economic zone, because the adjacent state has the exclusive right to exploit all the natural resources in the exclusive economic zone. That's 200 nautical miles from the archipelagic baselines of the Philippines. So it's very clear, historic rights have been extinguished. Now, beyond the EEZ, beyond the exclusive economic zone, in the water column, all nations have a right to fish in the high seas. So no country can appropriate the fish in the high seas exclusively for itself. It belongs to mankind, part of the common heritage of mankind. Underneath the water column of the high seas, the coastal state has extended continental shelf, a right to exploit exclusively the natural resources up to 150 nautical miles from the edge of its exclusive economic zone. Again, it's very clear. Other states cannot claim historic rights. So, UNCLOS is very clear. We don't have to talk about historic rights when it comes to the law of the sea. It's very clear, beyond the territorial sea, historic rights have been extinguished. That is the ruling of the arbitral tribunal in the South China Sea arbitration. Why did the framers of UNCLOS decide it that way? Because the only way you can preserve peace and stability in the oceans and seas of our planet is that don't claim any more historic rights, because there's no end to it. If you allow historic rights to be claimed beyond the territorial sea, Italy can claim the entire Mediterranean Sea, because that was called the Mare Nostrum of Rome, our sea. We don't want that. We don't want Spain and Portugal to claim the rest of the ocean and seas, because under the papal bull, they were awarded all the territories and seas beyond the what was known then as the Old World. So very clear, historic rights do not apply beyond the territorial sea, and we should stop talking about it anymore. Just accept. Under UNCLOS, under the international law, there is that principle of pacta sunt servanda. You must comply with your obligations under the treaty in good faith. Let us be in good faith. Let's just follow what is there expressly stated in UNCLOS. So let's go to the other dispute, the territorial dispute. It's governed by general principles of international law. We can use history here. China published a 3-volume book, Ancient Maps of China, the maps of China during the dynasties. And in all these maps of China, Hainan was the southernmost territory of China. Chinese territory did not go further south than Hainan. Now, what is the value of this 3-volume book published by the People's Republic of China, official publication? That, you know, the rule in international law is maps don't decide territory unless it's attached to a treaty. But there is an exception. If a state voluntarily publishes a map against its own interest, it is bound by that publication. And that was applied in the Pedra Blanca case between Malaysia and Singapore. Malaysia voluntarily, unilaterally published a map saying that Pedra Blanca belongs to Singapore. And the tribunal said, you're bound by that, even if it was unilateral, because that is an admission against interest. If you publicly admit something against your interest, you're bound by that. So all this 3-volume book of China, ancient maps of China during the dynasties, show, without exception, that the southernmost territory of China was Hainan. China is bound by that. Now, China in 1932, when France occupied the Paracels, China protested officially. In a note verbal, it said, China announced to the world, our southernmost territory are the Paracels. So China moved from Hainan to the Paracels. 1932, China announced to the world, our southernmost territory are the Paracels. You have to cross the South China Sea, high seas, to reach Scarborough Shoal and the Calayan Island Group, or the Spratlys. So 1932 already, China said, our southernmost territory are the Paracels. 1943, as shown in the book there by my friend Francois, China published the China Handbook, 1943. In that handbook, China said, our southernmost territory is Triton Island of the Paracels. Triton Island of the Paracels. China is bound by this. We are already in 1943, and China has been saying to the world, our southernmost territory is Triton Island of the Paracels. That's far from the Spratlys or Scarborough Shoal. In 1947, China revised its handbook. This is an official publication, the handbook of 1943 and 1947. China published its revised handbook. For the first time in China's history, China claimed the Spratlys. They called it the Coral Islands. So first time that China in its history claimed the Spratlys was 1947 in the China Handbook of 1947. But when China claimed it, China said in that book expressly, the Coral Islands or the Spratlys is also claimed by the Philippines and by the French in Indochina. So that is a fatal defect because you can claim only if it is terra nullius. You can claim territory if it is terra nullius. Terra nullius means land that is not claimed by anyone. So that was a self-defeating claim because they claimed it on the basis of discovery, but they stated in their claim somebody else has claimed it, the Philippines. So China came to the picture very late, 1947. And in 1947, in the 9-dash line map of China, which is now called 10-dash line, you will see there's Scarborough Shoal without a name. There is just a dot there. China claimed everything within the 9-dash line, and one of the dots there is Scarborough Shoal, but without a name. We are already in 1947, and China still has no name for Scarborough Shoal. We gave a name for Scarborough Shoal in the 1734 map of Pedro Murillo Velarde. We called it Panacot. And in the 1808 map of the Philippines, the second official map of Philippine territory during the Spanish regime, it's there. Bajo de Masinloc or Scarborough Shoal, also in the 1875 map. So, in the territorial dispute, it's very clear that China came to the picture late, and we have been claiming Scarborough Shoal and the Spratlys since 1734, officially. I end here, thank you.
Very much, Justice Capio. And last but certainly not least, Chang Pham. Thank you.
Thank you very much. And I see that our chair is growing anxiety because of the constraint of time, so I will be very brief. For my part, I think I will echo with Justice Caprio and also other panelists in this panel. I will say that My main argument is no country in the South China Sea can establish historic right in this sea area. And I can prove it in fact and in law. So it's impossible for any country in the South China Sea to claim historic rights in the South China Sea. The first reason is geographical impossible for any country to claim that because the South China Sea is a wide open sea. And from the historical facts presented by Bill Hayton and also other panelists in here, that no country in the history can control this wide open sea alone in order to exclude the exploration and exploitation of natural resources from other countries. The first thing, geographically impossible to claim historic right. The second reason is legally impossible to claim historic rights in the South China Sea. Now, in order to claim historic rights, it has to be special because historic rights demand something very special in order to trump international treaty like the Law of the Sea Convention. Before the Law of the Sea Convention, the South China Sea or the coastal state in the South China Sea can only control the belts of no more than 12 nautical miles around their coastline. So the vast open space of the South China Sea is open sea for anybody to go and fish and conduct all the activity in this sea area. So before the Law of the Sea Convention, it's an open sea, it's the right to fish for everybody in the South China Sea to fish in that area. And with the Law of the Sea Convention, as our panelists here already points out, no country can claim the right to fish or to explore and exploit natural resources in the exclusive economic zone which provided in the Law of the Sea Convention. And after the come into force of the Law of the Sea Convention, it's basically illegal to claim historic right to fish in the exclusive economic zone of other coastal states in the South China Sea. So the last reason that I say impossible to claim historic right in the South China Sea is concerning legitimacy. In order to establish historic right, you need to have the consent, the approval of the specially affected state. And if you look at the reactions of all other countries in the South China Sea, you read their notes verbal at the Commission on the Continental Shelf at the United Nations, you will see that all the countries in the South China Sea verbally and expressly rejected the idea of historic right in the South China Sea. So I agree with my panelists here is that we should stop talking about historic right in the South China Sea because it's impossible legally, geographically, and legitimately to claim these rights in the South China Sea. Thank you.
Thank you so much, Pham. Just before I get to Q&A, I have a question that I would like to pose to all our panellists, and actually it bounces off what you've just said there, Pham, and that is that one of the objectives of this panel is to find pathways towards reconciling historical narratives. And I wonder about whether this is really possible or even desirable, given that these are competing narratives and they're not just historical, but they are political and strategic, and that they are competing to become dominant and hegemonic for the purposes of legitimising claims. So I wonder about what our panellists think about whether it is actually possible or feasible to reconcile some of these historical narratives that we've heard today. But I would like to, I'll let you sit with that question and I will go to the audience. I see that there is a hand up the back. I hope we have, you should have a microphone. Yamamoto-san, yes.
Okay. Thank you so much for very basically historical. So I have one very general question to the Dr. Wu. It's okay. So Dr. Wu referred to the relationship between the Judge Yanai-san of the ITLOS of the justice and the former Prime Minister, Japanese Prime Minister Abe. My and our understanding is that judges are expected to make decisions individually, independently, and that those appointed to the head of the international institutions and organizations should not be influenced by any single government, I understand. So while Dr. Wu's concerns about the Judge Yanai differ from our understanding, would it be correct to say that such a view is common in your country? China has provided many distinguished individuals, very good experts, to the head and lead the international organizations. Does this mean they are strongly influenced by Chinese government? This is my question. Thank you.
We have a question down here. Thank you. Yes.
Thank you very much.
I'm not sure that's working.
Can you hear me?
Yes, perfect.
Thank you very
Thank
much.
you.
Atsuko Kanehara, Canon Institute for the Global Studies and also Sasaka Peace Foundation. I would like to make a brief comment from a perspective of international law, as I am the first president of Japanese Society of International Law. According to China, historic rights are based upon history, but at the same time, they say that the historic rights are based upon customary international law. Let's look at China's statement on the occasion of South China Sea dispute. I hope my memory correctly serves me. China did not appear the tribunal, arbitral tribunal, but China issued voluminous statement on that occasion, like pleadings to be submitted to the tribunal. And they say China's rights are in accordance with customary international law. Regarding this, my point is any rules of right to be customary international law should satisfy the two requirements, namely state practice and normative conscience of the world. I think China's historic rights or China's rule of historic right are not customary international law. Customary international law is not a tool to legally justify any claims that violate existing international law. Thank you very much.
Thank you. I'm going to take 3 more quick questions before going back to the panel. Furuya-san. Sorry, we can't hear you.
Hello. Now it's okay. Thank you. Thank you very much. I'm Professor Kentaro of the Grapes and Keiwa. My question is also going to Dr. Wu. I'd like to hear your explanation on how to draw 9-dash line and its nature within the 9-dash line. I understand that you concentrate on the territoriality of the maritime futures in South China Sea, but my question is how to draw the 9-dash line. Assuming that your statement is correct, and then all those maritime futures are China's, but how do you draw the line, and also the nature of the line? Thank you very much.
Thank you very much. Jay, if you could make it quick, thank you.
Thank you, Beck. My question is to Justice Carpio. I would like to hear his comments and explanation about the claim of Dr. Hu that the arbitral award is illegal and not binding. Thank you.
Thank you. Could you please repeat that, Jay? Could you please repeat the question for Dr. Wu?
No, my question is for Justice Carpio. I would like to get the reaction of Justice Carpio when Dr. Wu said that the 2016 arbitral award is illegal and not binding. Thank you.
Thank you. Aizawa-san?
Thank you very much. I'm Riho Aizawa from Japan. So could you...
Sorry, we can't hear you.
Okay. How about that? Okay. Thank you. Yeah, I think it's good. Yeah. Thank you very much. So could you... I'm not a specialist on international law, so could you share your thoughts how and to what extent these discussions on international law can be useful and meaningful in addressing the issues in South China Sea? The difference we see at the stage have been highly politicized and appears to international law often serves mainly to demonstrate the rightfulness or rightness of one's position. So yet such contests of legitimacy do not seem to bring us closer to resolution to me. So from your perspective as experts in international law, what elements are still missing in the current approaches to reach solution? Or in the end, is coercion the only remaining answer? Thank you very much.
Thank you. I'm going to take two more quick questions. I can see there are more hands up, and I'm sorry, but we are running out of time. Ristian?
Thank you. Ristian Supriyanto from the University of Indonesia. My question goes to Dr. Wu. We understand that China keeps insisting on the 9-dash line. Sometimes it was 10-dash line, sometimes it's 11-dash line. And China even calls it the dotted lines. And this claim has generated protests and criticisms from other countries, including my country. At the same time, China also insists that its claim is consistent with UNCLOS. So my question is, how are you going to make this 9, 10, 11 dash lines consistent with UNCLOS? Thank you.
Thank you. And finally, Ian.
Thanks. So my question goes to Dr. Wu as well. I'd really like to explore this idea of historical rights and also restitution for colonialism. Because if I note correctly, you talk about the Great Tang. So if you look at the Kangju Dudufu, right, this is currently in areas that are controlled by Uzbekistan, Tajikistan, Turkmenistan. If you look at the Treaty of Aihun of 1858 and then the Treaty of Peking in 1860, clearly Haisengwei or Vladivostok has been cut off to Russia. These are not disputes, historical disputes that the PRC continues to chase. Why is there that difference?
I'm very sorry to those who are not able to get their questions in. I'm going to now return to all of our panelists to get their brief thoughts on some of the comments that were just raised. I'll start with you, Dr. Wu.
Okay, how it comes so many questions for me. The first question to my Japanese friend. Let me address your question in this way. In 2015, when I was in Ottawa, Canada, I met Mr. Yunai. He just stepped down from UNCLOS as the president. I directly asked him, you are, as a Japanese background of UNCLOS president, you should avoid to nominate the judges or arbitrators to deal with this case or arbitration that will be initiated against China. I don't think the judges nominated by you will deal this case impartially, objectively. But unfortunately, he didn't answer my question. So that's my answer to your questions. To your question about why China didn't appear, the cause you mentioned the customary international law. But in my opinion, Chinese official stance to the arbitration and arbitration ruling is 3 no's: no acceptance, no participation, and no recognition. Why? The main reasons are: number 1, from Chinese perspective, the tribunal has no jurisdiction over the Philippine submission concerning South China Sea historical rights and 9-dash line, and the 9-dash line and the related historical rights, because China's, maritime entitlements in the South China Sea inextricably linked to 2 questions. One is territorial sovereignty over land and the maritime interests in the South China Sea. And also, the tribunal wrongly denied the integrity of South China Sea, Nansha Islands, and also erroneously concluded that Taiping Island, the largest naturally formed island, Taiping Island or Turaba, and the South China Island, and another South China Sea islands are not eligible for claim EEZ and the continental shelf. So it's wrong. And also the critical conclusion of the UNCLOS, of the tribunal says the UNCLOS leaves no space for historical rights is highly questionable. Why? Because the historical rights can and will coexist along with UNCLOS. And another case has already confirmed this, so that's the main reason. With regard to the questions, 9-dash line. 9-dash line, we call it the dashed line or U-shaped line. The background was soon after Japan surrendered, because from 1939 to 1945, the South China Sea Islands was occupied illegally by Japan. Before that, it was occupied by France. So Japan surrounded, then Chinese government, ROC, according to Cairo Declaration and the post-proclamation, recovered the South China Sea Islands. And then the first draft map was appeared in soon after China recovered the South China Islands in 1947, and officially published the dashed line, 11-dashed line, in 1948. The new China, the founding of the People's Republic of China, inherited the dashed line. So what is the meaning of the 9-dash line, in my opinion? If we look at the statement published by Chinese government soon after the July 12th, 2016, the arbitration ruling was issued. It says, the statement says, China has sovereignty over Dongsha, Xisha, Zhongsha, and Nansha Islands. And those islands have internal waters, territorial sea, contiguous zone, the continental shelf. And China enjoys historical rights in the South China Sea. So that should be viewed as a 9-dash line meaning. Historical rights, another colleague mentioned historical rights. The arbitration ruling denied China's historical rights in South China Sea. It says, if we look at the ruling, it says China, based on historical rights, asked for or claiming for natural resources falling within that line has no legal basis. But I would say, we look at the international practice, the case between Eritrea and Yemen in 1998, and the case between Tunisia and Libya in 1982. Historical rights is an ancient right that stems from the coastal states' long history, practical or physical practice in relevant maritime areas. No matter you made an official declaration or formal notification, the historical rights is there. So China's historical rights in the South China Sea was there, is there, and will be there, no matter China claims or not. Thank you.
Thank you. Bill.
Hi, thank you very much. I'll try and answer your question about pathways to reconciliation, but I will just say I think I've knocked the Cairo Declaration on the head, okay? It says nothing at all about the Paracels and the Spratlys, and the Potsdam Declaration didn't either, so no need to talk about Cairo and Potsdam anymore at all in any convention ever. So the pathways to reconciliation, it's easy, okay? Here's the answer. Everybody just agrees to keep what they have and go home. Okay, simple. Now, China has created an organization called the International Organization for Mediation, which sits in Hong Kong. Not many countries have joined. But how about this? How about China offers to take the territorial disputes to the International Organization for Mediation and to sit down with the countries of Southeast Asia and to actually properly mediate on the future sovereignty of those islands. Okay, that's my suggestion. We know the IOM is basically set up, well, some cynics might say that it's set up to destroy international law and put Chinese-led mediation in its place. But obviously I'm an optimist, and I don't believe that. So I think this is a fair tribunal, and I think this should be given its first test to mediate on the South China Sea disputes.
Sorry, very interesting point that was actually raised at the South China Sea Conference in Da Nang earlier this week. Ah, there you go. Did you want to say any final comments?
I think there should be a natural reserve in the Spratly and the Scarborough Shoal, but not unilaterally like China did a few weeks ago. It should be a common affair. In fact, it should be all the claimants countries, and even outside the claimant countries, who should be together and create this common ground, common organization, but never unilateral. That is very dangerous, in fact.
Thank you. Final thoughts, Justice Carpio?
Yeah, I will answer the gentleman who asked what is my response to the claim of China that the tribunal was constituted illegally because it had that it had no jurisdiction. China basically claims that it did not give its consent to the arbitration, and consent is required before the arbitral tribunal can acquire jurisdiction. And second, the tribunal has no jurisdiction because it's a territorial dispute. Now, on the first, when you ratify UNCLOS, you give your consent in advance to any future arbitration under UNCLOS regarding the application or interpretation of UNCLOS. It's there. If there is a dispute, one party to the dispute can request that the dispute be submitted under the compulsory settlement dispute mechanism of UNCLOS. So that's what we did. Because China gave its consent in advance to any future arbitration. Just like in the Pact of Bogota in Latin America. All countries signed the Pact of Bogota, and they said if there is any territorial, maritime, or any kind of dispute, we agree to submit it to compulsory arbitration in advance in case of a future dispute. That's allowed. That is giving your consent in advance. So there was consent. The second, China said that the tribunal has no jurisdiction. But there is a provision in UNCLOS. In case the jurisdiction of the tribunal is questioned, the tribunal itself shall decide whether it has jurisdiction. And in this case, the arbitral tribunal ruled it has jurisdiction. So it's all covered. Now, China did not participate physically, but they are bound because they gave their consent in advance. But China, even if it did not appear, it submitted a position paper. It submitted it to the tribunal. This is our position paper. And in that position paper, China said, Philippine territory is defined in 3 treaties. The 1898 Treaty of Paris, the 1900 Treaty of Washington, and the 1930 Treaty with the British demarcating our boundary in southern Philippines. So China said, those are the 3 treaties that define Philippine territory. We agree with China. In fact, it is in our constitution. China even quoted our constitution of 1935. Philippine territory is defined in 3 treaties. We completely agree with China that Philippine territory is defined in 3 treaties. But where is the difference? the Second Treaty of Washington. Because in the Treaty of Paris of 1898, Spain ceded to the US only the islands within the treaty lines. That's very clear. We admit that. But when the Americans came here, they found out that there were many islands belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris. So they again talked to the Spaniards. They said, hey, there are many other islands outside the treaty lines. They negotiated and they signed the second treaty, the Treaty of Washington. And it says, there's only one article in the Treaty of Washington. There's one of the shortest treaties in the world. It says, Spain also cedes to the US any and all island belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris. Very clear. The second treaty clarified that all other islands belonging to the Philippine archipelago lying outside the lines were also ceded. China admits that Philippine territory is governed by the Treaty of Washington also. They're bound by that admission. And where do we find these islands belonging to the Philippine archipelago lying outside the line? You go to the 3 official maps of Philippine territory during the Spanish regime. 1734 Pedro Murillo Velarde map, you see there Panacot. Panacot is Bao de Masinloc, which is also called Scarborough Shoal. In the second official map of Philippine territory during the Spanish regime, you have the 1808 map. It's there, Bajo de Masinloc or Scarborough Shoal. And also, the rest of the Spratlys are there. The last official map of Philippine territory during the Spanish regime, the 1875 Carta General del Archipelago Filipino, it's there also. Scarborough Shoal and the entire Spratlys with depth soundings with names of specific features that are above water at high tide. And when the Americans came here, the map that they brought with them was totally wrong. They discarded that map and they adopted the 1875 Carta General of Spain. Exactly the same map. They put their War Department Office, 1901, 1902, 1899, 1900 map, 4 editions. So if you visited the Philippine government office in Manila in the 1910, 1920, 1930, you will see this map, the 1875 Carta General, as the map of Philippine territory. And you will see there's Scarborough Shoal with depth soundings, and the entire Spratlys are there with depth soundings. And in the very famous international case between Netherlands and the US on Islas Palmas, they disputed who has sovereignty over Islas Palmas. That's an island off the coast of, in the southern tip of Mindanao. The first arbitration on territorial dispute in Asia was between the US and Netherlands over an island in Mindanao. And the Americans, to prove that Islas Palmas belongs to the Philippines, submitted the 1875 Carta General. They said, this is the official map of Philippine territory during the Spanish regime and during the American regime. And that is why this map is very important, because it is the map that tells us Scarborough Shoal and the Spratlys have been part of Philippine territory since 1734. Thank you.
Thank you. And finally, Pham.
Let me quickly talk about the legitimacy of Judge Sun Chi Yanai when appointing arbitrators for the South China Sea arbitrations. So the South China Sea case is an arbitration, and party to the dispute can choose their arbitrator. So if, and it's according to UNCLOS, if one party didn't appear, the responsibility of choosing the arbitrator belongs to the president of the International Tribunal for Law of the Sea. And it happened to be just a Japanese judge named Sun Chi Yanai. And he's just doing his job. The job that given to him by the Law of the Sea Convention itself, and if he based on any other reason rather than the law, he will betray the convention, as well as all the member states at the United Nations voted for him to be the judge, at it lost. And China can just avoid all of that by appealing to the case and choose their own arbitrator. Because they didn't do that, and because of the law of the convention itself, that responsibility belongs to the president of UNCLOS. And it happened to be a Japanese judge. And I think it's very legitimate for him to do his job. And if you look into the 5 arbitrators of the South China Sea case, I really challenge you to prove that they are not impartial. Thank you.
Thank you very much. I'm sure that you will agree with me that this panel has set an extremely high standard for discussion for the rest of the Manila Dialogue, so please join me in thanking them.
Thank you, panelists. Once again, let's give them a big, big round of applause. We may kindly remind everyone that you may take coffee and snacks and bring them to your table. But otherwise, we will transition immediately to the next panel. We apologize for the inconvenience.
Good morning, sirs and ma'ams. We will now proceed to the second plenary session of Diplomatic Roundtable. May we request on stage Professor Victor Dindomanhit, President and CEO, Strat-Based Group, Vice Chair, WPS Advisory Board. We would like to request also His Excellency David Hartman, Canadian Ambassador to the Philippines,